additional notifications as people continue to trickle in, but why don't you kick it off in the meantime?
All right, good deal. Can you hear me okay?
We can hear you great.
Okay. Well, I'll share my screen here as well if you let me. Yeah, so for those of you that haven't met, Ferd Niemann, I own and operate mobile home parks in the Midwest. Also have a broker's license. I used to be a financial analyst, don't do that anymore, but I also am a licensed attorney, represent probably about 150 park owners, sometimes small scope, look at a zoning letter, sometimes full scope of contracts, title survey, loan docs, PPM, syndication docs, zoning, business stuff, some financial analysis, sometimes DD. Um, so here to help. You got some questions? If people want to jump in, they can ask questions whenever. Otherwise, I'll leave some time at the end. These are some slides that I put together for a presentation at SECO. A couple years ago, I spoke at SECO MHP conference. So it's got more in here than we'll probably get through today. But I'll go ahead and see if I can get this in slide presentation. Go from there. All right. And my contact information will be at the end, or otherwise you can hit me through the app that you guys are using, school, or whatever it's called on the website there. So disclosure, I'm not your lawyer, or if I am your lawyer, I'm not your lawyer for the next hour. This is all just generic information, um, not any one particular matter or client specific. So really, I want to just kind of hit off on some key provisions to put in the purchase and sales contract, I think, and kind of why they're important and go from there. Sometimes people take this for granted and don't do some of these things. This first one's kind of easy, right? The legal name of buyer and seller. It's ideal. Like if you're buying that, most time we represent buyers, like 90%. So if you just put like, some people put owner of record, okay, that might work. But like if the seller is, Chicago MHP Land LLC, like you want to know like who the right person is because if there's a default, you want to know you can potentially lien the property or get some sort of recourse from the seller. If you don't know the seller's name, you could look it up at the county GIS records or county records. It's pretty easy to figure out. You find their name, and then if you want to know who's the right signatory, I had an issue where I had a client that he signed a contract, and the seller was, Chicago MHP Land LLC, and was signed by, Jim Smith. Well, turns out Jim was not the authorized signer, and we didn't find out till closing, and we wasted a lot of time and money on that's kind of lesson learned. Like you want to try to have the title companies, the neutral party, say, hey, verify right out of the gate that the seller, the right person is signing the contract, or get some sort of representation to that effect. The title company could be your friend on this. Like I said, I got here in the notes. Also, to make sure the signature page has the correct names. I've seen it at times where, you know, somebody that you think you're dealing with John Smith, and then the signature page comes in and it's, Jane Doe. And you're like, wait a second. Is John or is Jane the right person to sign here? Doesn't come up that often, and not the easiest, not the biggest issue to fight over, but just, it's a basic item in there. And some people ask, hey, if I'm the buyer, do I need to form an LLC in order to sign a PSA? I prefer it. You don't need to. I could sign a PSA Ferd Niemann. Obviously, I'm not going to close on the property in my name. It'd be fake. So you want to have it say Ferd Niemann and or signs and create an LLC. But if your first deal, that's probably how it's going to be for you. But if you're doing more than one deal or you're planning on doing more than one, I would just create like a brand LLC. Like I've got Niemann Investment Group LLC, and that entity doesn't do anything other than tie up property and then assign it to a PSA, to a new special purpose LLC. And it has a checking account, and I have it's licensed to do business, and it has liability insurance, and it puts the earnest money in, and it maybe spends money in during DD, but that's it. So that would be best practice. And the reason is like, let's say that you end up defaulting on a contract, you get sued. It'd be nice that the entity that gets sued is not you personally, or not an entity that owns significant assets. So my brand name LLC, typically only has $5,000 in checking. If I'm buying a property and I need to put $20,000 earnest money up, I'll make an owner contribution into that LLC checking account, and then that entity will write a check for the earnest money. Uh, the assignment provision. This is one of the most important provisions to get right if you're a wholesaler, or if you're doing some sort of 1031, etc. And really, it's the buyer's right to assign. So this is, you see section 20, there's an excerpt out of my contract, but you see the difference here. It says, I'll go through this. Buyer will have the absolute right and authority to assign this contract. On assignment, the assignee will succeed to all of the rights and obligations of buyer under this contract and will, for all purposes of this contract, be substituted as the buyer under this contract, upon which assignment buyer will be fully and forever released from all duties, liabilities, and obligations under this contract. So what's that mean in English? Couple things there. You just the way you pitch it to the other party is, look, I'm going to create a new LLC at closing. Okay, cool. And then great, you can. But you also notice here, let's say that if it's my name personal, Ferd and assigns, then it'd be, oh yeah, see, I'm going to assign to a new entity. If I assign to a new entity and they let this provision go the way it is, I'm going to say I'm off the hook. It's a new entity. New entity has no real assets. It's kind of like an extra layer of liability protection for me. Now, if I wanted to wholesale it, to sell the deal to Michael and say, hey, Michael, I'll give you rights to this contract for $10,000. I don't want seller whittling down this language. I want to have this broad language, and I want to have it where there's no trailing liability for me. Once Michael's in, and hey, it's his problem now. If he defaults, if he digs and hits a gas line, it's on him. But so if I'm representing the seller, I'm going to try to pare this down. I'll say, okay, fine, really strong and say, oh, you can't assign unless unless I sign off. That's kind of unreasonable. So I'll say, okay, dear buyer, I'll let you assign the PSA, but you're only going to assign it to a new LLC that you are the manager of and the majority owner or the controlling member if it's a syndication. And I'm going to narrow that scope. And I'll also say, and under said assignment, the new buyer will assume the responsibilities, but not all of the risks. So the underlying buyer, because what I don't want to do is have the person I think I'm negotiating with get off the hook. So having this assignment, this provision there can be very helpful. Property description, this is pretty basic, but you want to make sure a legal description from a surveyor or title company is better than the address. You can do county record search, you can do a property tax legal description, but addresses are not legal descriptions. I like to take a picture of Google Map and then like put a red polygon around it and then some hash marks, because if you photocopy in black and white, you can still see the hash marks. And then you can just have that in there too, so it's crystal clear. If there's an issue, I want to be able to lien the property. Don't leave this blank. People often say like property description, like, oh, to be inserted later. But then, let's say the person defaults. I had this happen one time and I got unlucky. We had the polygon for this property and the guy had represented, he had a treatment plant that was not working. He's like, I just bought a $350,000 guts for this treatment plant, and it was included in the contract. Well, we went and looked at the property, and we still wanted it. Where's the treatment plant? Oh, it's off-site. It's in some warehouse. It's like being installed in 2 weeks. Well, then the guy says, I don't want to sell. I changed my mind. Well, we had the property we could lien, but without the $350,000 treatment plant, we didn't like the purchase price. It was, we were paying $1.7 million. It was worth, without, let's say it was worth 1.8 million. Good deal. If there's a working treatment plant and under the contract, he had to put it in there. But when he bailed, we could lien the property. Well, then we're leaning a property with a broken treatment plant. And we didn't learn, I learned a lesson from experience, I guess. We said that the property being sold included all the property located at this address. It just didn't occur to me, and at this legal description, didn't occur to me that the treatment plant would be off-site. We didn't think to ask pre-closing. So having the address in there can be helpful, especially if there's more than one parcel. Having an address and legal description and an image makes it more clear. And then on the personal property, mobile homes, you want to have a description, year, make, model. Ideally, you have copies of the titles. They don't have to necessarily be in the contract, but you want to have those as well. If there's any equipment or intangibles of any real value, like branding rights in the marketplace or colors or signage or website, or equipment like, I bought properties that have come with a skid steer and a zero-turn mower and an F-250 and a trailer. Like, you want to make sure it's written in there so you don't let it get away. You want to break down the purchase price. It's pretty easy putting in there, but if you have seller financing, you want to articulate, by a promissory note or a mortgage. I typically don't offer a personal guarantee in full recourse, so we just leave it in there secured by a promissory note or a business loan agreement. And then that may help you at the time of drafting the loan documents closer to closing. And then earnest money, you just want to be clear on this, like what, I would say never pay it directly to the seller. And then if it's a wholesale deal with an assigner, you got to figure out who's paying what and where's it going. So you just want to spell this out. When's it due? Where's it going? How much is it? Is it applicable to purchase price? When does it become non-refundable, if at all? When does it become non-applicable or released to the seller, if at all? So just put the specifics in there. Okay, right of entry. This is an important provision for, and this provision helped me win a lawsuit against a seller that seller decided to change their mind. I was under contract for 5 million. He was doing a 1031. Apparently, he couldn't. His other deal fell through. He no longer wanted to sell to me. I'm like, so he wouldn't let me on property. He wouldn't let me get inside this clubhouse, the garage area that was necessary for my loan to get an inspection of this. It wasn't worth that much money, but it was necessary to inspect the buildings for my, this is a Fannie Mae loan. So the guy that would let me in, well, I said, look, I have the right of entry. And if you notice, whoops, too far, about 3 lines in, it says, I can investigate and inspect the property and to perform at my expense such tests, surveys, inspections, and investigations deemed necessary appropriate by me, including for the general usability of the property for buyer's use of mobile home park. So I told this guy, part of my right of entry includes inspections deemed necessary by me. I deem it necessary to allow my bank's appraiser inside this clubhouse and garage building. And he said, well, no, you've already been on site. I go, I've been on site, but I have an additional inspection. I have the right of entry. And he refused it. So I sued him for specific performance and made him sue or made him sell. And then actually what happened, kind of dumb bad luck that for him and for me a little bit at the time, cap rates were really low. I had a bank approval at like 4.5%. Well, by the time this took a year of fighting this guy, um, interest rates had gone up to 6.5%. Well, all of a sudden I couldn't get the same loan. Now I got to put like 50% down. Well, then I didn't have 2.5 million laying around, so I was going to use investors. Well, then it's a worse yield for the investors. All of a sudden I didn't want the deal as much. So he didn't realize that as much as I did. So he ended up paying me, over $250,000 to go away, to then not buy his property that was now worth in the marketplace less than 5 million. But this provision made it clear that I was going to win. He wasn't giving me the inspection, and he also wasn't giving me some other one or two other items, which I can cover later. So you always need to have a right of entry. It's standard practice for the seller to make sure that if you do damage, you got to fix it. So like that's hard to get rid of that. And typically, sellers are going to insist on additional approval if you're going to do boring or drilling or subsurface work, like in a phase 2 or phase 3, really a phase 2 environmental. Okay, the title commitment. This is reviewing the title commitment is more important after you get the contract, but you want to have good language in there as to who's paying for it, what type of commitment is it, what is the objection limit? How can I object on anything or on only certain things, and what's that timeline? Are there any what type of policy and so on? And then also, like, let's say I object to title. There's a lien on the property and I don't like it, or I had one where the guy didn't have good title and own it was an easement, road, but then eventually the easement was abandoned and the road went to him, but he didn't went to the previous guy, but then my guy didn't buy it properly. So I looked at the title, I'm like, you don't really own the road, and I kind of need the road. So the language we had in the contract says he must cure it. And that means even by payment of monies. Well, what if the guy next door or the deceased guy's family that used to own it, what if he wanted $1 million for to sign the new quitclaim deed? Well, the contract says you got to pay this guy $1 million. So you want to build, if you're selling, you want to tighten that down. You want to, the buying, you want to make it where everything has to be cured if it can be cured. And then I want to be able to get my EMD back if you can't, like if you practically can't, or I want not just my EMD, but I want reimbursement out of pocket expenses and DD costs. Now it's hard to get that in the final form of a contract, but it's not that fun. Like, okay, great, I got 30,000 out of pocket costs. I get my 30 back. That's not very fun. Or even worse, I don't get my 30 in out of pocket. I just get my 5,000 EMD back. That's no fun. So I want to say, look, I got time. Where you usually start is you go for it, and I want consequential damages. Like I was going to make $1 million in 1 year on this property. I want the $1 million. They're not going to. Anybody that reads it's not going to go for that. Some people don't read it. You get the A+ language in there. But if you give them the huge reach, and they whittle it down, then you may land somewhere in the middle. As opposed to a lot of contracts don't start. They start, you know, at like the 1 yard line. I kind of start on the other 1 yard line. I try to land at the 50 yard line. Also, who pays for the survey and when it impacts the shot clock, that's important. So like if I say, look, I'll pay your price, but you got to pay for a table A Alta survey, and my DD doesn't start until I receive title and survey. They may not know that a survey might take 6 weeks, and they may not know that it costs $15,000 for a property of this magnitude. So it's just kind of, the art of the deal on this is try to put in as many favorable provisions as you can get away with. And helps you with the negotiation as well. Risk of loss and condemnation. This is pretty standard. And basically, you just want the right as a buyer that, look, if the property gets taken by eminent domain, or there's a big insurance claim, or really any insurance claim, I have the right to terminate, or I can proceed and we get the proceeds and or some sort of credit. Okay, DD period. Everybody knows what this is, I think, but when's the shot clock start? Does it start at the effective date, or what if the seller doesn't deliver? So then you got to put the seller default. I like to have it say the shot clock starts upon the last that I receive of DD materials, the title commitment, and the survey. The survey is a reach because you could stall those out pretty good. Title commitment depends on the company you're using in the busyness of that time of the year, but sometimes it takes a day, sometimes it takes 3 or 4 weeks. So you may want to push back on that if you're the seller. And then when's it end? That's specific. You can either have a floating, like a hard deadline, or a floating date. Most people have a floating date, like it ends 30 days after the start. And then the start, we've already talked about when that is. Um, Typically, you want to make sure you have the absolute right to kill the deal for any reason or no reason prior to that expiration. And you want to make sure the notice section is complied with. We typically like to have email delivery, so because it's easy to do that in a moment's notice, as opposed to, I've got some clients like, no, it's got to be arrived at the title company. Well, that means we got to wait at least, you got to make the decision at least one day in advance. Another option is to have your deal be auto hard or auto live. Auto hard is basically like, look, if I don't terminate it, it's automatically I've waived my IP. Others way you can draft it is, look, if I don't terminate if I don't send an extension notice, then it's automatically terminated. Pros and cons of each. I'm not that big, not that worried with either one, but you want to make it very clear for the title company, because if you have ambiguous language, they're going to hold up your earnest money. So, and you want to use a title company you can predict. And I have words in there like, this is buyer's sole and unilateral right to terminate. And there's more language like, and this sentence shall serve as the sole authorization, and no seller or title company authorization is required so long as we meet these dates. Because I've had it happen where title companies, I had a deal where it's like 30 days in, we had 60 to 80 days. Like it was a crystal clear. It had not been 60 days. It said, hey, pursuant to section 9, we terminate the contract. Please send the earnest money back. And the seller said, hold on, don't send it back. There's a dispute. I was like, what are you talking about, dispute? He goes, well, you were really difficult on the contract negotiation, so I spent a lot of money on lawyers, so I don't want you to get all your money back, and I lose 3,000 on lawyers. So tell you what, I'll agree to give you your earnest money back if you cover half my legal, 1,500. No way. Well, title company's like, look, there's a dispute, and they wouldn't give it back, even though. So then I tell the title company, basically we're gonna get in your business, and we're never gonna use you again. But you're hereby directed to give it to us, and sometimes they'll still be like, no, I don't want to do it, and they'll hand it off to the state, and then you got to go fight. Then you got to go file a lawsuit to get your earnest money back. So once you have a title company that's like that, never use them again. Um, okay, extension period and fee. Do you have an extension period beyond the initial inspection period? And if so, do you have to pay a fee for it? Typically, you should to have consideration for it. And then how do you do this? Do you send a letter? Do you wire money, etc.? Is the fee applicable to the purchase price, or is it just I'm a wasting your time extension fee? That's all negotiable. Here's a list of, I'm sure you guys all got stuff like this. This is a list of seller deliverables. We put these in the PSA, and we have a footnote that says, you need to we'll mark off on received. And if you don't have them, we don't remove them from the contract. We make the seller initial, not applicable initial, because otherwise I've seen inferior lawyers, they'll say, they'll let something like this happen. Like let's say uh, third-party reports, item C. Let's say that the seller really does have an unfavorable property condition assessment report or unfavorable EPA report. If it's in here and they have to give it to you, then that's going to be really hard for them to sell. So sometimes what sellers will do is they'll just delete row C, and then they'll put in their uh, intentionally deleted, and they'll tell us email, hey, we don't have any of those, so I removed it from the contract. Well, then if you find out later that they had it and they were lying, you can't go after them because it was not a requirement for them to produce it in the contract. It was only in the first draft of the contract. So I say, no, 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 that item C is staying in there. If you don't really have it, you can initial and say, I don't have it. And you can represent and warrant to that, because there's other reps and warranties in other sections of the contract. And then if I find out you default, you're in big trouble. And all these hypotheticals I'm giving you, I've seen happen more than once. Some of these are in here as just trick bags, like S, list of 5 best and worst aspects of the property. No reasonable seller should ever answer that. It's a trick. It's trying to get them to disclose stuff that they shouldn't. And I mean, I've seen people say like, oh, the best thing is all the tenants are Mexican. I've seen people say all the worst things are the worst thing is all the tenants are Mexican. Like you're just opening yourselves up to liability for comments like that. And I've had people say like, well, the downside is, you know, the three houses up front, they're well, the person doesn't really live there. They just store it, and I'm not sure they're going to pay rent because the homes are not livable, and we'll probably have to demo them one day. Okay, well, that impacts. I didn't know that when I made my bid. Now that I know that, we need to revisit the price. So these are trick bags. These are one helpful to get information for you during your DD, but two, it's a trick bag to see if the seller gives you something negative, and three, it's a trick to see if the seller defaults and or four gives you more time because a lot of times sellers will just here's the thing the lawyers almost never read these. The lawyer will say to the client like I don't know this stuff. They'll say yeah, this all looks normal, and then the client will just not read the whole contract, and they'll just assume that the lawyer read this, and then it's crazy because you'll have something happen where I'll um I'll say, hey, you guys turned in all the documents, but you didn't give me your tax return for the last 2 years, so we don't have all the deliverables, so we're now 15 days in and we're on day zero on the shot clock, and they'll say, well, I don't have my tax returns. What do you mean? Well, I haven't filed yet. Oh, well, under the contract, you said you would. So I guess you better hurry up and file. Or if I'm gonna have to proceed in absence to tax return, I might need more time because now I got to work through more banks or whatever. Or you're even in theory, or you guys are in default. Now in order to waive my default, let's talk about you throwing in the F-250. So each of these things is in here for a reason. Um, And then some of it is the primary reason is this: you don't have access to stuff. I don't often know the age of the materials, the infrastructure. It'd be nice if they pull that, and if they represent they're going to list age, and they come back and say, I don't know. Okay, well then they don't know that's honest, but sometimes you can trip them up on these. I'm not trying to be a jerk. I'm just trying to protect my client's interest. Okay, seller covenants. These are basically promises, like big time promises. Reps and warranties are similar, but here's the covenant that really has worked out well for me. Have them terminate all personnel, employment, vendor, and service contracts prior to closing. Because they often don't do this. And they don't realize that they signed a long-term contract with the security company or with the trash company or something. And I'm not going to take it over. And then if the trash company tries to make me, I'm going to say, not my problem. That guy was legally obligated to do it, and you didn't record it. It didn't run with the land. It wasn't a title commitment. I'm not taking over the contract. And then if you have like bad manager, I had one lady, I interviewed her. I was thinking about rehiring her. Well, she was a disaster. So I'm like, I don't want to have to hire her, but I couldn't like tell her that right away because I still needed her help, like getting through DD because she was worried the other guy was gonna run out of money and she was gonna lose her job. So I was like, hey, show off for me kind of thing. Well, right, a week before closing, I said, hey, look, our budget is in and you're making $80,000 to manage this one park. We only have up in the budget 35,000 for a manager. So I mean, I'm sure you could be overqualified. I just can't pay you 80,000. So she's like, what? And she quits. Well, she quit on the other, she sent a letter out quitting. So that really helped. But then after closing, she filed for unemployment. Well, she filed against the seller. Well, the seller doesn't own the property or any business anymore. So then she tries to file against me and try to get the state of Missouri to say that I was a continuation of the previous business. I say, look, I don't know if the other guy fired her or not, but he had a contractual obligation. So I'm going to sue him and be like, hey, man, you breached the contract. You got to pay this woman's unemployment. But luckily I found, I got it from the tenants. I got a copy of the letter where she basically, thanked God for her being God's gift to property management and then handed it out to the tenants saying she was choosing to spend time with their father. Well, the contract provision can help. Getting that letter also helped to get out of unemployment claims. Same property, they had a security camera contract that this manager signed 10 years at like $1,000 a month. And if you terminate, you have to pay the rest of the balance. So this is like 18 months in, I buy the park and the seller's like, hey, you didn't take this one over. I go, I didn't take that over. Well, I didn't even know about it, one, but you were required to terminate it. So I don't want to have to inherit these contracts. A lot of them are bad. Similar with, but I'll tell them unless I tell you otherwise. So like during DD, if you show me you have a trash contract or water or so on, then sorry, in the notes popped up distracting me. If you have a favorable trash contract, I'll keep doing it. But if you don't have a favorable trash contract, I don't want to inherit it. Same thing with property management contract, etc. And you want another covenant in that they're going to continue to operate the property up to closing. I've had the problems with this enforcing it, to be honest. But we're under contract, and the guy I was buying from just said, "All right, I guess I can stop mowing the grass now. We did our DD. Okay, it's only a week. It's only a week in. The mowing's only a week long. He's not running the property that well. Well, then like 3 or 4 weeks go until we get all the loans set up and get to closing, and he hadn't mowed again. We show up on day one. We didn't go back. It's probably our mistake. We go back on day one with the whole crew of guys, do a bunch of work, and then the guy that's supposed to mow was like, "Yeah, he told me not to do it anymore. When I got another job, I can't do it for 4 days." So we had to get the mower and hire somebody else to mow. The grass was 3 feet tall. It's crazy. So you want to make them continue to operate, and then continue with compliance with city rules and such as well. Reps and warranties, these are important that you want the seller to, you want to make sure they say they have the authority to sign. You want to make sure they don't have any options or other rental agreements, or ROFRs, other than what they've described to you as mobile home tenant leases. Now, certain states have statutory tenant rights and ROFRs, so sometimes they also trip them up. Well, they'll just sign this provision not knowing that there's a state law, and then you can either let them circumvent the law to their detriment, or you can use it. Hey, I see that you got to give them this ROFR. Maybe you can use a number. I need more time. They need time, etc. Sometimes I'll put in a really aggressive offer on timeline, knowing the seller's not going to deliver. But okay, I'll close in 30 days, but looks like you need to do X, Y, and Z. You want them to rep stuff that even though you can verify on your own, you want to put some teeth in it for them. Like they have to rep that there's direct vehicular and pedestrian access. You make them a rep that there's no legal actions or proceeding against the property, etc. No condemnation. Make sure they have all the licenses, etc. I make them rep that there's no rent control. I'm gonna look that up myself anyway, but it's always nice to have the seller promise to do something, because then you can make them go do the work and prove it up for you, or you can potentially have an out if they don't do it. The second to last one's kind of and again, like kind of like I said earlier on the seller liberals, I don't let them just strike them from the contract. Like, no, you need to say yes, no, or not applicable. You need to represent. Like, to the best of my knowledge, there are no active lawsuits. You can't just have them delete the paragraph that says there are no active lawsuits, but then have them email saying, no, we don't have any. So we'll just remove that one from the contract. Like, no, the thing gets removed from the contract. And then the trick bag one is you make them say that they rep that the property shall not go down in condition or value. And they're thinking, yeah, it'll be the same. But then like, what if a house pulls out? You say, whoa, I just bought a park yesterday. House pulled out the week of closing. So we had a discussion about it yesterday. Get a little, I got a small price concession on the day of closing, and we didn't have a contract amendment even. We just emailed the title company to give me a credit on the closing statement and seller a debit. Like, look, you guys are in default. You want to fight over this, or you guys want. So I can be a little challenging at times, as my wife says. Other things, conditions precedent to closing. This is a kind of a inspection period plus or trick bag, if you will. These are usually things that are valid conditions precedent to closing, meaning potentially closing requirements, even after the inspection period. And I tell them where I'm reasonable if the seller's got a competent attorney, I'll say, look, I'm willing to waive my inspection, but I can't control what I can't control. So if I don't have the appraisal back yet, the bank's, it's 30 days to close and the bank hasn't got the appraisal, if the appraisal falls through, I can't close. So like that's outside of my control. Yeah, I got to pick the lender. Yeah, I could have ordered it earlier. So look, if the survey, the phase one, or the appraisal comes back bad, or there's no insurance issue, then I get my risk back, even if it's like the morning of closing. These are generally heavily negotiated along with seller reps. I typically, when I buy, I don't have a financing contingency. That really helps to get the offer accepted. If I'm just like, look, I need to do my inspections. I need uh, I need 30 days to look around, and I need 30 days to close because I got to get a loan, but I don't need a loan contingency. I'm confident in my banking relationships, my balance sheet, et cetera, that I'll get it done. Like, okay. And then that usually gets me more likely to get it signed. And then that sleight of hand, I can leave in a provision of like, okay, what's this appraisal? I thought you have a financing contingency. I go, well, I don't. I'm not saying I need a contingency to get financed, but if like the appraisal comes in low, why should I have to buy it? Okay. So you kind of negotiate to keep things in. Prorations, I see errors on these all the time. Taxes get prorated wrong. Wrong parties paying for escrow fees or document stamps, transfer fees. I always avoid local custom because most people don't read it that closely. And there's like, they're used to like, oh, every time I sell, the buyer pays these fees. And then I just like put in there like seller pays these fees. And then they sometimes do. And then later on, especially in the LOI, this is helpful before the attorney gets involved. You have a binding LOI, which is great. And then the attorney's like, no, our local custom is you're going to pay him. I'm like, well, I don't care if your local custom is. It's $17,000. And I put that in the LOI that your client I negotiated, and if I knew I was going to pay 17,000 more, I need a price concession. And they're like, well, the LOI says LOI wins, right? Um, I put background in the contract, and I kind of like bury it in there two different ways, so they sometimes catch it, and then they don't catch the second one because they kind of lull themselves to sleep. Like, wait a second, we already addressed this, and they move on. Like, no, rent not paid for preceding months of closing uh, goes to buyer. That is another way of saying buyer gets the back rent. So I put it in there twice in different sections, and they'll be like, no, no, back rent. And the seller's attorneys, or the average seller's attorney is a B student. So, you face an A student guy, okay, you gotta cave on some of these. But there's a lot of B students and there's a lot of C students that are like, yeah, I'm an attorney, but I do divorces, speeding tickets, and wills. Oh yeah, my friend's selling his trailer park. He asked me to do the contract. I'll do this one too. And sometimes they don't have lawyers, or lawyers don't even read them. It seems like I've had lawyers respond to my super favorable contract, copy their client. Looks good, Jim. Go ahead and sign. I'm just like, you didn't have a single thing in here you didn't care for. Next up, closing sections. I just say typically there's X days after DD as opposed to a hard like outside closing date. Like if it's 30-day DD, 30-day extension, 10-day close, doesn't mean we're closing 70 days after the effective date of the contract. It's going to depend on when the shot clock starts. You want to make sure you have all the closing deliverables, the deed, assignment of leases, bill of sale, a note or a mortgage, or deed of trust. There's an assignment of notes, for, you have to take over 21st mortgage repurchase obligation. You want to have any tenant notices that you want them to provide. You want to articulate that, make sure they give you the keys and the codes to the buildings and so on. Obviously, you want to make sure the funds are available. Anything else title company requires. 1031 documents. You want to make sure if you're planning on doing a 1031, you've got the right in the contract to require the seller to cooperate. Best practice to make sure everything's done in the right order and nothing falls through the cracks is to have your lawyer send a closing instruction letter with the details. So seller default provision, this is really important. Typically, if the seller defaults, you want the right to specific performance, and which means they have to specifically perform and sell you the property, which precludes them from going with a higher offer once you've got another contract. I've seen guys do that, like, hey, sorry, I know we're under contract at 4 million, but some other guy just came in at 4.5, so I'm gonna go with him. I know you've been working on this for 3 weeks, so don't worry. I'll tell the title company to give you your earnest money back. Sorry, it didn't work out. Sorry, you paid for this, that, and the other. Sorry that you were getting a deal, so on. Like you cannot let this. You cannot. This is like the non-negotiable here. Um, plus you want to aim for damages at law and equity, lost profits, lost business. You're not gonna get all those in most cases, but you want to at least get specific performance plus any legal fees used to enforce it um, paid back to you. Try to get like, hey, if interest rates go up, I want to get paid for the interest rate too. You also want the right that if they default, you can just terminate the contract, get your earnest money back, and get your extension fees back. And ideally, you get your reports paid for, your DD costs paid for, your loan application fees. And you want to say if they don't pay them, sometimes they won't pay them. Like, yeah, okay, sorry, you get the earnest money back from title company, and they're like, I'm not paying you 40 grand. And you're like, and the guy didn't have any money, he's broke. All right, I want to sue you, and I want those fees to become a lien on the real estate, so I can tie it up forever. Other default provisions, typically there's a notice period. Like I got to give you a certain notice and there's a right to cure. Okay. I always try to go for more than one option or remedy of seller default in my first draft of the contract. That way, if I end up having to, I let the other guy win. I got 3 arrows to shoot at him. If I let him knock out one or two, he thinks he wins, but I still get one or two, as opposed to people go for just one arrow and then they don't get it, and you fall back on and get your earnest money back. Like whoop-de-doo, get your earnest money back. You want more than that. Okay, the buyer default provisions. Whenever I'm buying, I'm saying, look, the sole remedy is you get the earnest money. I'm not gonna let you sue me for specific performance. You can never agree to that. I had a client that happened to. He went under contract at 5 million. His acquisition guy told him 100 sites at $500 rent. Okay, 5 million, good deal. They get under contract. They didn't hire me to do the contract, and the opposing party was a U.S. attorney. The U.S. attorney owned the park. It's an RV park, and he had in there buyer specific performance. He had to know that this was overpriced. My client goes and looks at it and they said, hey, there's not 100 sites times 500 rent. There's only 50 sites times 500 rent. His acquisition guy goes, oh, yeah, yeah. But the guy told me there's twice as much ground to expand. So I figured one day we'll get to 100. Like, what? We just valued this thing as if it was 100. So my client is buying a $2.5 million property for 5 million. They say, hey man, we're out. We can't get a loan. He goes, no, you have to buy. You'd be defaulting because they had an inspection period. They already let it lapse. So now they were at the closing period. So they had waived their rights to bail. So now they had to close. And they got sued for 2.5 million. So where I kind of got them out of it a little bit, I think and these guys, their buyer account, their brand LLC, they had done a bunch of wholesale deals in there, and they had a ton of cash in there, a ton of like seller receivable stuff in there. So they had over 7 figures of cash. And I'm like, this guy's going to sue. He's going to get access to your bank account. You're screwed. So what we did was we basically said, hey man, nobody's dumb enough to put money in their buyer account. This ain't doesn't own any property. Tell you what, you knew it wasn't real at 5 million. Write it up at 3 million. We'll do an amendment. We'll work on earnestness for 1 million to get it to buy it at 3, and we'll give you $100,000 earnest money, non-refundable, released right now. And the guy's like, yeah, that sounds pretty good. I'll still get 3 million. They were never going to close at 5, and I'm going to get 100 grand. My client gives them 100 grand, walks away, and never did anything on it again. And they didn't buy; they lost 100 grand, but they saved $1 million in checking account. So never agree to specific performance. If you listen to anything else I say, as buyer. Okay, buyer, you want to minimize as many reps as possible, and you want to have the seller help with your DD. Seller will, verify this. Seller will do this. Seller will provide this. Seller will provide the police report. Seller will provide, will verify there's no rent control. And you still want to double check it, but make the seller go find the statute. Make the seller get the license copies. Make the seller, do this and that and the other. Also, when you're buying, you want to have at least a day of cure period, because sometimes like a wire transfer takes 2 days. We had it happen on a deal where it was the day of closing and the wire didn't go through, so we were in default in the last day of the closing period. But if they had to notice us up in default and we have at least a business day to cure, well then okay, the wire went in the next day, we were good. I've had FedEx not show up on time, etc. I've covered notice provision indirectly in a couple other sections, so we'll go through that. Survivability, this is super important. When you're buying, you want the seller's reps and warranties to, quote, survive closing. That basically means if you find out later that the seller was dishonest and they misrepresented something, you can still go after them. The timeline is negotiable. It often lands at a year. You don't want 6 months, because a year is enough time that like the tax bill, like I bought a property one time and there was no now I had no knowledge that there was a special assessment for a water district. It wasn't billed by the county, so it wasn't on the county taxes, so I missed it. And the title company missed it for the same reason. And this guy's financials were disastrous, so I didn't notice that like once a year he paid this extra bill. So it was only like $500, so we just moved on with our life. But what if it had been 15,000 and he knew it? He knew he was paying it. He just didn't tell us. Well, this provision here would say, look, you represented, there's no other special assessments or taxes. There's proof there were because you've been paying them, and you represented there were none. So you owe us, and these reps survive closing, so you owe us $15,000. Broker provision. Brokers just want you to have this in here. If you're a broker, you're supposed, like I am, you're supposed to disclose it. You also typically want indemnification. Like, look, I don't have a broker, but if you do, it's on you, and I'm not paying him. Otherwise, the broker may pop up later and demand payment. And if you already own the property, they may try to lien your property. Section 1031s, the tick and drop swap. If you're going to do some of that stuff, you're going to want to make sure you have a contract provision in there, because it's going to add a lot of legal fees, including on both sides, if you got to review a bunch of other docs and draft a bunch of docs. So you want to make sure that it's in there. Ideally, you want to make it where you don't have to pay the other side's lawyer. Miscellaneous provisions, these are all pretty generic, I would say, except for I don't want the seller to allow backup offers, because I don't want them, like if I'm under contract at 4 million and I'm getting ready to retrade at 3.9 and he gets an offer at 4.5, he's not going to accept my retrade. So I want to say there's no backup offers, and I also want to say it's take it down from marketing, which they never do because the brokers are never in the loop at this point. And then later on, if you have a problem, you can be like, hey man, why is your broker still out there marketing the property? And that's why you're not giving me more time, because you got another offer out there, don't you? So it doesn't come up very often, but I've had it kind of help out once or twice, and you don't get a lot of pushback on these provisions. Exhibits, you want the legal description. The purchase price allocation is important if you want to have do a cost seg. You may want to allocate it one direction for purpose of income tax. If you're worried about the property tax increases, you want to allocate it a different way. If it's a disclosure state, that may impact it. The ideal situation is just says buyer may allocate any way buyer desires. And ideally up to or after closing. I typically don't put the allocation in there anymore because it gives you one more thing to negotiate or fight over. And most time the other attorney doesn't know what they're doing. So they want to ask the other CPA, and then CPA gets into it, but CPA doesn't understand the whole thing. And then you're slowing up your contract because you're waiting for an argument between the CPA and the seller's attorney. So we just leave it in their blank, like our allocation, and it seems to go through pretty well. If there's seller finance notes or mobile homes, you want that in there. The seller deliverables that we talked about, a rent roll. And then typically you can put these other forms to be signed at closing. You can have be in the PSA or you can negotiate them later. I typically negotiate them later because it makes it easier to get the PSA signed. And I can negotiate them after, like right before closing while the other side is already counting their money. And then they don't push as hard. And you get better, it's more favorable. Your bill of sale, your assignment of leases, form of your deed or a note, etc. If you have an escrow holdback agreement, that's for something like, seller's going to pay for X or build Y after closing. I'm going to pause there because that's PSA stuff. We got a whole bunch of other documents that we can cover, but I know that's taken about 45 minutes, so or about 40 because you started late. So I'll stop there. Any Q&A, there's a lot of information to throw at you guys, but really those are some of the key provisions and rationale for them in the contract. And one other quick story on, I negotiated a deal for a client and there was a 21st mortgage repurchase obligation and the seller's attorney doesn't know about trailer parks. So he's just a regular real estate lawyer. So I knew that seller had repurchase obligation if these homes defaulted, but her other attorney did not put that in the contract. So as we get closer to closing, he asked for a payoff statement from his lender. He goes, oh yeah, I need to get payoffs for the mobile homes too. I got some debt on some of those. Some were just the debt. So we knew he had 21st mortgage because he had debt on the rental homes. So we said, okay, he's got to pay those off. We're buying those as rental homes. And the guy goes, wait a second. You also got to take over the repurchase obligation for the 30 homes I already sold. And my client's like, what do you mean? Like, well, if the people default, you got to buy the home back from the bank. I go, we don't want to do that. He goes, well, yeah, it's part of the deal. He goes, where's that in the contract? He goes, so we said 30 homes at 50 grand. That's 1.5 million. He goes, well, not all going to go bad. Well, how many are going to go bad? I don't know, 10%? It's $150,000 of pain. So I said, so the contract as negotiated, the seller was going to be in a situation where my client was going to own the park. And if those homes defaulted, the seller who no longer owned the park was going to have to pay them off. So we had him over barrel. So we said, okay, let's talk. Now that that's different, now that we got a different price or different risk, we need to have a different price. So these provisions can really help you if you have problems. You don't need to use them all the time. I don't retrade every deal. I try not to. But if the other guy's being a jerk, not giving you access, not giving you deliverables, misrepresented something, then you're going to be glad you had a better contract than he did.
Thank you, Ferd. I'm going to open the floor to questions. So if anybody has any questions, please either put them in the Q&A or just type into the chat, and we'll bring you to the stage to ask that question live. Just to get it kicked off here, Ferd, I think just a general question about contracts for those of us who are new or just entering the space, or maybe have done our own contracts or accepted contracts from sellers, as the buyer. Would you say in a general sense that it's probably most important that you are putting forth a contract as the buyer versus taking a seller's contract, just because that gives you a lot more leverage, and it also potentially cuts down on legal fees since you don't now have to review an existing seller contract and add your own provisions?
Yeah, good question. So it's always in your interest to draft the first form. If you're buying, you do the form. If you're selling, you do the form. And one is it is cheaper. I can turn around my own contract in less than 30 minutes. I got to read the other one, read the whole thing. It's going to take 2-3 hours. Now, if they redline mine back, I'm only reading the red. So I'm not rereading the whole contract. I've read it before. So it's actually saves time, but that's like secondary. If you're making decisions based on an hour or two illegal, you're in the wrong business. That's pennies compared to the risk you're taking when you buy something. So you want the stronger contract. The other benefit is if I throw a contract at seller and I got 10 provisions there he doesn't really like, if he redlines all 10, He looks like he's a deal killer lawyer, a lot of red. So there's gonna be pressure. And this happens to me. I'm a seller. I'll tell, like, I'm saying, Michael, I got this contract. There's 10 things that I don't like, but that's gonna be a lot of red. So here's what I'll tell you is these three we're definitely redlining. These two on you. These other five, we can live with it. Just look at the DD differently on this or ask for this, you know. So the guy who goes second is sometimes is more timid and needs to be more timid on the red line. And then so that's the first part of that. Also, broker contracts are not ideal for the buyers because think about it, what do brokers care about? One thing and one thing only: money. They're all whores. They'll do anything for a dollar, right? How do brokers get paid? Only if and when you close. So the broker form contract that the brokers, lawyers, and the National Association of Realtors put together, who do you think they had in mind? The buyer, the seller? No, they had the brokers in mind. Now, they made it neutral enough so that people will probably sign it. So my contract might be, first draft might be like 70% favorable, like 70-30. And I try to land at like 60-40. The broker's contract is going to be like 49-51 because they got to be signable by both. But the one is favorable to the seller because when do brokers get paid? At closing. When do they, and they get paid if sellers get to closing. So they want to give the buyers less outs. Now they're reasonable enough to say buyers get 30 days inspection period, any reason or no reason, but they don't have the feet to the fire. They don't have the default provisions thing. They don't have the deliverables. They don't have the extensions and all those sort of things. So broker contracts are 51% seller favorable. If you're the buyer, you need to have the one. You need to be ideally you're 60-40, you know, but you need to have at least the one. If somebody asks, can I share the PowerPoint? Yeah, I can get that over to, there's more in it than we covered here today, but I can send that over to Michael and he can circulate it. There's a question about capital raising and somebody's in here too. And then Michael, fire off whatever you want on these two. Ryan, good seeing you too.
I was
All
gonna
right,
say
Emma.
I got questions too, but Mike, let's open it up to everyone else.
Emma Norman just asked a question. What are the costs related to putting a lien on the property? What states are most likely to let this happen? How many of those have you seen paid?
The cost is going to depend on what the fact pattern is, but typically you're going to file a pretty basic lawsuit. You know, at least 3 or 4 thousand, but probably less than 8 or 10 to draft a lawsuit and some recording fees. I've done it a few times on deals of mine. I've got one right now. The woman that I bought it from, she sent me photocopies of the title, photocopies of the applications to the DMV. They were from, and the DMV was supposed to send them to me. I paid her for these homes, and then we closed, and then the title company sent the titles to her still. They goofed. She didn't give us the titles. She went door to door trying to sell these homes that we'd already paid her for the whole park and the homes. So we filed a lawsuit, and because she had a personal name on it, she didn't own an LLC and she owned a nice house next door. We are leaning her nice house next door. Um, and I can record a memo of lien to have it a Liz pendants. I can even get insurance on the property in case she burns it because she's crazy. So what states are more favorable? I don't know by hand. I mean, you should go do it in any state. I mean, you got to get a job. You know, it's called a Liz pendant, which means lawsuit pending, kind of like a mechanics lien. Like if I pay somebody to fix my roof at my house and I don't pay them, they get to sue me. Here you get it's a little harder. Mechanics liens have an expedited process. I haven't done it very many times. Is you know, it comes down to is the juice worth the squeeze. You know, we do a lot of zoning matters. And I'll tell clients a lot of times, like, look, I think we're going to win, but it's going to cost you 150 grand. Do you want to get that one lot back or do you want to move on with your life? Like, yeah, I don't really want to fight the city that hard. At the beginning, people are like, I'm fighting the city, bring it on. I don't care what it costs. But we've only done a few zoning lawsuits, but I've had 20 clients tell me, I'm going to sue the city over this no matter what. And then it comes time to start cutting checks and start pissing off the city. Most people cave. So it's kind of like that on these is, you know, I'm not going to sue over 5 grand unless I'm really pissed. I sued a transport guy once over 5 grand and I jacked in a bunch of legal fees and stuff because he paid him and he didn't show up. And he's like, yeah, sorry, I paid a sub and they didn't show up. You know, you get the money that's not how it works. And I wanted to win the lawsuit so I can badmouth the guy. His name's Dion with Gold Standard. I couldn't say that for a long time because it would have been defamation, but now I got a judgment, so I can say it. So don't hire Dion. That's the real reason I filed it was to put him out of business.
So for another question here, Alice says, if you transfer title from out of state, can you hire someone local to transfer the title for you?
The mobile home titles, Yeah, you can. You gotta find somebody. Um, it's really easy to do a transfer title DMV. I would just find some. I mean, you got to trust somebody. Find somebody on Facebook. From some. I need a drone video. I find some college kid on Facebook for $50. I wouldn't do that with a title. Probably, I would call the title company, call the DMV, and just see can you do it via mail. We've done that before. Just do it via mail, and then tell them it's coming. Get an email, send them a copy, all that kind of stuff. There are companies like Snickfish, I think, is one that does them. I think they're a little pricey. I think somebody told me they charge like 500 a whack when it really only takes like 15 minutes plus wait in line. Assuming you got all the docs in order and stuff.
Great. I have a question here from Walter. I think this is probably going to be more of a consult after the fact, but start to finish, what's a typical legal cost to provide your template, customized to an offer, and then assistance with the back and forth negotiations with their lawyer? I think that's going to be an it depends answer, but I'll let
Yeah,
you.
anytime there's two parties, there's always it depends. I mean, typically going back and forth on a contract, it's half an hour to draft it, and it's anywhere from 0 to 3 hours negotiations. If they sign it at 0, typically I'd say it's an hour and a half back and forth. The bigger entities, bigger players, are gonna have better lawyers, and they're gonna catch more. They're gonna push back more, and then typically we go after that. We go to title survey review. That's anywhere from 1 to 3 hours, depending on what the easements are, and then zoning research is anywhere from 2 to 10, depending on the code, and then depending on what you got to fight the city. And then loan docs, if it's local bank docs, it's like 0. We don't really negotiate those. If drafting, it's like 2 3 hours for seller finance, and then CMBS is a huge animal. Your legal bill on CMBS is going to add at least 10K of legal fees on buyer side, and then you got to pay at least double that on lender side typically. So the better loan terms at a local bank, but it's a lot of fees, a lot of hair. Fannie Mae loans are not as bad as that. Um,
All right, Carrie's got a couple questions here. I'm going to
Template,
let
I
her.
think I sell the template for like $500 if you just
Oh,
want the
no.
template contract. Um, Go ahead, Carrie.
All right. I have a couple questions. One, I am in helping a team infill a bunch of lots. Is there any general things I should watch out for when infilling? And then the second question is, I had a consult with you about raising capital, and I was trying to explain it to somebody else, and I'm like, I don't think I fully understand this yet. So I just want to understand the raising capital, how to do that correctly. So those are my two questions.
Okay, on the raising capital, yeah, where people do it incorrectly is they do what's called money finding, or they get paid a referral fee, which is by rule black and white a violation of SEC law. For like, let's say Carrie, I said, "Hey Carrie, I'm trying to raise $1 million for a new deal. I'm tapped. I don't have any money of my own, and all my friends and family are out. Um, I need help. Could you help me raise $1 million? I'll give you 3%. I'll give you 30 grand." If we do that, we both just committed SEC felonies. So the way you got to do it properly is my first syndication, nobody knew who I was. Nobody's going to send me money on the internet. So who am I going to ask for money? Friends and family. So they're my buddies. So then I can do a Reg D 506B, B for buddy, and I can raise money from my buddies. My buddies can be accredited or sophisticated. Accredited means they got $1 million net worth, excluding their personal residence, or they have an income of 200,000 a year for the last 2 years, and the current year 300,000 if they're married. So accredited are rich guys. Unaccredited, you got to be sophisticated. It's like my little brothers. They're smart enough guys. They both have master's degrees. They're teachers though, so they don't make that much money. And their master's degrees are not in things that make them sophisticated in understanding the risks associated with the real estate and legal matters such as this syndication. So my brothers do not qualify as sophisticated, and they don't make enough money or have enough net worth to be accredited. So they're not allowed to be in any of my deals, even if they have the money. They do. They're good at. They save a lot of money, and they mow grass in the summers, and they got the money. I don't let them in because it's against the law. Now a 506C, it's got to be accredited only. Can't be my buddies unless my buddies are also rich guys. Now the benefit of 506C is you can advertise it on the internet. So now when I raise money, I just closed on a deal yesterday. I raised some money on it. I got a bunch of people on my email list. I just sent out one email. That's marketing because I don't know all those people. You have to have the sophisticated. You also they have to have a pre-existing materially significant relationship, not somebody I just is friends with me on LinkedIn. that can be work on the 506C. And these both are under a private placement memorandum, which is a legal document that has all the disclosures and risks and so on. People don't like PPMs because they cost like 10 grand, anywhere from like 7 to 12, depending on the deal. So that's an extra cost, and they're confusing for you, and they're even more confusing for you to articulate to your investors. But that's the proper procedure for raising capital legally.
But if you're part of a, okay, if you're asked to do it as part of a team, like, do you have to be part of the LLC? Like, let's say there's a portfolio of 3 parks and you're taking it down with a team. Do you have to be part of the LLC? Like, how does that
You don't have to be
all?
part of the LLC. So let's say back to my example. I say, hey, Carrie, I need help raising $1 million, but I don't want to get in trouble, neither do you. Here's what I also need. Like, instead of paying you 3%, like, would you like to be part of this deal? And I'm most of the deal. I'm the guarantor. I'm running construction. I'm running the day-to-day management. But you know what I really need help with is sales and leasing, back office support, posting ads. I need another set of eyeballs on the budget. I need some help on the DD. I need some help with investor relations. Would you like to be a co-GP, and I'll give you 5% of the deal?
Yeah,
Now we might be talking compliance. Here's where people try to get cute with it though. They'll say, yeah, Carrie, it's gonna be 5%, if you raise half of the 1 million. But if you raise all of the 1 million, it's 10%. That's too cute. That's gonna be money finding. So if you're a co-GP, it's legit, but you're supposed to have a material role. And here's where people get in trouble. Like, oh no, we're just doing a co-GP model. And I'm like, how many co-GPs you got? Well, there's like 8 of us. Really? You guys inventing, fire? I mean, what are you doing that's that complicated? You need 8 general partners. Everybody else seems to be able to do it with 1, 2, or 3. So, oh, by the way, what's Dr. Bob do? Well, Dr. Bob's a surgeon. What's he doing in this park? Well, he's putting in all the money. Do you know Bob? Is Bob passive? If by rule, if I'm active and you're passive, that's a syndication. Whether you call it a joint venture or an operating agreement or a banana, that's a syndication. It's not a banana. And if it's a syndication, you got to do a PPM.
yeah. Okay. I gotcha. Okay.
Follow-up question, and we'll go back to your other one. Can you help funds raise for private loans and get an origination fee? Um, it probably depends on the specifics. If you're sourcing debt and you're just getting a commission or referral fee, that's probably okay. Don't quote me on that because I haven't really dealt with that. If you think about if you think about a real syndication, if I'm asking people to invest in my mobile home park, what am I offering them? I'm offering them a membership interest in real estate in a company. That's a security. If they're not active partners with me, they're passive. I'm offering them a security. Um, there is a legal way to do that. It's called the fund to funds model, where the fund guy has his own PPM and he invests in there. And you see there's a group called TribeVest that does the legal paperwork on that, pretty cost effective, but it's pretty nuanced. But yeah, just help raise funds for private loans. You probably can get away with that at a minimum. I don't know if it's 100% legal. Yeah, you assessing the South stores and the debt. I mean, you're probably not violating the SEC laws, but you're probably violating some other laws. So like wholesalers, for example, tie a deal mobile home park up, flip it to the next guy, charge a $10,000 fee. That is basically practicing brokerage without a broker's license. Now, the pain for them is they don't really have a broker's license to lose. So what do they care? Versus, if Ryan is not a lawyer and Ryan's trying to be practicing law, he doesn't have a law license to lose, but the law association takes it kind of seriously, and they may go after him from some other penalties. It can happen. In my hometown, there was a guy that was he was kind of a wheeler and dealer selling and leasing commercial property. And in Illinois, you need to have a brokers and or property management license to do that. Well, everybody was kind of looking the other way. Then he had a big network. Then he put out a flag, Jim sells houses. And he started putting up realtor signs, and the Realtors Association had him a cease and desist letter in a minute, and they were gonna take him to the real estate commission and go for fines because they didn't want him competing in the residential market. So you probably need if you're sourcing debt, you probably need some sort of mortgage loan originator license or broker's license. But I mean, I know it happens all the time. So I don't know that it's completely kosher, but it's not going to likely be the same as the money finding SEC violation. Okay, back to Kiri's other question on infill is what to look out for. Infill is the most profitable mechanism to add value in mobile home parks. It's also one of the most challenging. So there's a lot going on there. The market demand, do you need permits? Is it you need a HUD set, different type of concrete? Do you need a licensed installer? Do you need a licensed electrician, water, sewer? What are the setbacks? So I got to upgrade the pedestals. What's my grandfathered zoning rights or lack thereof? Am I allowed to bring them in? Can I bring in homes the same size or bigger or smaller, singles or doubles? Do I need to upgrade some other infrastructure? Um, if you're doing it for hire, you just want to dig in deeper. I don't think I have a podcast specifically on infill. I have a podcast, a couple episodes on diligence, so I may have got into more detail, but I basically just covered it. You can call the state MH association, who's the licensed guy. Depending if it's a used home, you got to go get it, take it apart. Does it have tires and axles? Bring it in, reconnect it. If it's a new home, it just shows up from the factory. Excuse me, and the factory doesn't. They don't install it. They'll have a trucker with a big long haul truck as opposed to a toter truck or a house cat or something install it. So there's a lot in there. Are the trees in the way? Insurance. What's the setbacks between homes or fire code? How far do you have to dig? What kind of some places that do you have to use Schedule 40 PVC? Do you have to put a septic in? Now are you over a certain occupancy threshold? You need to have a storm shelter. I mean, and that's where I made most of my money is infill, but it's also where I aged 10 years in the last 5.
Thank you, Ferd. I want to be cognizant of the fact that we're over here. I think there were a lot of questions about capital raising, and I think it might be great to have an entire session on that another time, since we did have a lot of questions related to it. One question that I'd love to ask you just to close out here is how can we be great clients for you when we come to you? Like, what should we have set and ready to go? And if we're engaging you on a long-term basis, like what makes us great clients for a lawyer who's been practicing for as long as you have?
Oh, that's a good question. I mean, we get clients of all shapes and sizes and quality. We get clients that one guy in particular, he always does a contract on his own, even though it's a crappy contract. He's like, it gets signed faster. I don't care. He doesn't. So I just say, I need the contract and do a conflict check, and we do the zoning, we do the title survey. We typically don't do bank docs for him, and we kind of closing instruction. So just be clear about what the scope is, because I've had another time where the client's like, they told us to do the zoning, but they didn't tell us that their bank, we weren't doing the bank docs, that their bank also hired PZR to do a zoning report. Well, we give them a zoning letter and a bill for $2,000, and then the bank puts a $2,000 charge, gets an inferior zoning report from PZR, and they don't want to pay us. I should have known. I'm like, you didn't tell me that. So just be clear communication, and then just reasonable expectations. Sometimes people will call me, hey, I just got a new deal. I need you to give me a contract in the next 30 minutes. Like, I'm driving from a meeting. I'm not going to be at my desk for the next 30 minutes. I'm not going to get that to you. Just reasonableness. And then, yeah, I mean, that's probably the big part. And then if you're organized, it's so helpful. We have some clients that they got it all. Here's the, LLC, EIN, articles, you have this, that, and we got other guys we got a guy today, he's closing on a $14 million apartment. And like, dude, somebody else did his fund paperwork. Like, I need an executed copy of your operating agreement and your PPM. I don't need the draft. I don't need, the 75. Like, so we DocuSign it. We have to get a copy of the draft and then send a DocuSign. Just being organized is huge. And then the client being responsive is always helpful, because sometimes they'll disappear on us for 3 weeks and then they'll pop back up and say, hey, I never got this, or I did, but we're closing tomorrow. What? So a lot of them let us kind of run quarterback. Some don't. We can make anything work though.
Fantastic. And for those of you,
Just pay your bill and don't be a jerk. We fired some clients that either were a jerk or didn't pay their bill.
for those of you who are listening who are not in our program, we actually have a whole data room that we set up for you on your behalf through the MHP Pros Mastermind. So I'd encourage you to join that so you can stay organized and help your attorneys as you're going through a closing process via like a system that's set up already. One last question that Ryan reminded me of before we let you go, Ferd, is how can we not intimidate with our PSAs on the theme of this specific subject? This is a question we get all the time. We just don't want to be intimidating, and then the buyer kind of pass us over, or the seller, excuse me, pass us over for another.
Yeah, that's a great question. And I call it my $1 million LOI, which I can get you guys if I don't have. And I call it that because I've made $1 million on a deal on 2 different occasions because I had this LOI. And I send the LOI first, and the LOI is not intimidating and it's really high level, but it includes specific performance and it includes binding LOI. And it says, in the event that this LOI is signed, the party shall use best faith efforts to sign a long form purchase contract. Well, best faith means they can't be as unreasonable on the provisions, not just good faith or reasonable faith. But in the event the parties cannot consummate a long form purchase in the next 30 purchase contract next 30 days, this LOI shall become the purchase contract. So I bought 2 deals on just the LOI because the seller refused to sign a contract, refused to hire a lawyer. Because I'm not signing a contract with a lawyer, I'm not paying for a lawyer. And so the LOI is huge. And here's what happens a lot of times. Sellers often don't get their lawyers involved on just a letter of intent. They do once they get a 30-page contract. It's not English. So if you get the LOI signed, you're already golden. Now you can be super aggressive on the contract because worst case scenario, you got to tie it up on the LOI. That's the way to do it. And then sometimes if I got a eight-page contract that's kind of like baby contract that if you got like a really bad mom and pop, some mom and pop will just doc you. I got a deal the other day I signed up, like last week. We docu-signed the contract and they just sent it back. Like they didn't even read. I mean, like in 5 minutes. So like whatever, you're paying our price. Now maybe the deal's a dog. I haven't looked at it yet in person. So maybe that's why. But tying it up with an LOI is huge. And if you know they're gonna, if they tell you in advance, like don't bring any funny business to the contract, then maybe you take out like 10% of stuff that's really really one-sided.
All right, Ferd. Like I said, I want to be respectful of your time. This has
Yeah.
been fantastic. There's massive value here. Thanks again. Is there anything you want to just close out with and tell people how to reach out to you? I've included a link to connect with you. A few people have already filled that out, and there are messages in your inbox, I believe,
Nice.
from individuals on this call. So that's fantastic. We will also have this recording available on our mastermind on YouTube and later as a podcast for those of you who like to listen on the road on your way to work. Otherwise, anything else that you want to close with here?
No, the only thing I'd say is if people know what they want me to talk about next time, I don't know, I'm coming on every month or two to guest lecture. You mentioned PPMs and financing. That's funny. If you know something else, let Michael know and he can let me know. And I got time to put it together if I don't already have notes. I got a couple presentations beyond this one that I got ready, so to speak. But rather than me choose the topic, you guys tell Michael and he can, or Ryan, they'll let me know.
Fantastic. Thank you so much, Ferd. Thank you, everyone who joined today. We'll see you guys on the next one, and just keep an eye out in the community. You'll see when we post the next webinar, whether it's Ferd or any of our other presenters. Thank you again, Ferd, very much. This was fantastic.